Hello and good morning. Thank you so much for joining us. My name is Kelly Nerick, and I'm the Senior Director of Products and Services at the Small Business Association of Michigan. And I'm very excited to have our friends from Mavacy back again. They are doing a legal webinar series for our members and talking about a variety of different topics. With us today is Carolina Polwaka and John Mashney with Mavacy. If you're not familiar, Mavacy is SBAM's approved partner for offering legal services to our members. So premium, VIP, or elite level members can experience the benefit of having trusted legal support for you and your business. They offer a Ask an Expert service on our website where you log in as a member and you submit a question and a fact-based answer is provided to you at no additional cost. Mavacy also offers our members a couple of different options if you are in need of legal services. So you can pay for monthly retainer rates, or you can choose to purchase specific services from their a la carte menu. So I will drop the link in our chat if you wish to learn more about the services that are available through Mavacy. But for now, I will hand it over to Carolina so she can get us started.
Awesome. Thanks, Kelly. And so I guess by way of quick introductions, John, I'm going to get the presentation up on the screen, but if you want to do an intro of who you are and your background, and then I'll do mine as well.
Yeah, John Mashney, practicing in the areas representing business owners, entrepreneurs, small businesses in multiple capacities, usually as kind of like a trusted advisor, outside general counsel, do tons of contracts, drafting, negotiation, review, buying and selling businesses, deal with intellectual property quite a bit and technology, and have a fairly good tax background and work on tax issues with clients. So across the board, generally, I work with business owners nearly exclusively, or the business themselves or the business owners. So that's a quick background. Really excited to be here with everybody.
And I'm Carolina Polwaka. I work with John at Mavacy, and as far as relating it back to today's topic, so when I first started practicing law, I was a litigator, and I litigated a bunch of breach of contract cases, and through that, I saw how bad a contract could affect a business, especially when it comes to litigation. So when I got out of the world of litigation, I switched over to transactional law and started doing things like what John does, which is a lot more fun and a lot less, I won't say less stressful, but it's definitely a lot less contentious. Litigation it's its own breed. But I've negotiated with, I'd say, over half of the Fortune 100 companies. I've represented clients when it comes to contracts in all different types of industries, whether it's just a small mom and pop shop, all the way up to like a highly regulated bank or pharmaceutical company. And when I approach contract negotiation, I think a lot of people hear contract and think, oh boy, it's whatever, it's just words on a paper. From my standpoint, coming from that litigation background, I approach it from the perspective of, okay, how can we use this document with all these words, yes, and how can we make sure that anybody who picks this up is going to be able to read it, understand what each party's roles and responsibilities are, and also do that in a very effective and efficient manner. And ultimately, my goal is to keep you out of litigating breach of contract cases, because they're not fun and they're expensive. And if you've ever been a part of that type of litigation, it's not great. So my hope today is that you walk away with a better understanding of what the importance of contracts. Hopefully get some pro tips on things to look out for. John and I certainly have a lot of stories that we'll be sharing with you, and just in general, we want this to be a bit more like a roundtable. So if there's things that, if you have stories you want to share, if you have questions, feel free to drop it in the chat. I'll be checking in on it, as will John. And yeah, let's get started. All right. Hopefully you can see my screen. All right. So classic dad joke. Today's presentation is just for informational purposes only, as our lawyers made us include this slide. So if you do have any specific questions related to your company, we're happy to discuss those offline. Yeah, just leave it at that. All right, pre-frame. So your business or your organization is a precious asset. You've spent a lot of time, effort, money in order to protect that business. And, there's a lot of things that go into that. And when it comes to contracts, again, even if it's lots and lots of words on the paper, the right agreement and making sure that you have the right terms in place could very well be the difference between your company shutting down and it remaining open for generations to come. One of the, I would say, foundational cases that I handled was the first lawsuit that I handled with regards to breach of contract cases. And my client was a family-owned business. They did masonry staining, and it was the husband and the wife. They owned it. The wife did the operations. The husband traveled all across the country doing the masonry staining, and their hope was to pass down the business to their son and have their other children involved. And it really was this legacy that and luckily they continue to hope to pass down to their kids and their grandkids and so on. So they ended up taking on a job here in Michigan, and unfortunately, when they got to the contract phase, they took a document that was a standard form, and then they ended up just writing handwritten notes all over it. And there were initials and there were things that didn't make sense. And ultimately, the document that resulted did not really make much sense, didn't really explain what each party's roles and responsibilities were. And it really was just a whole lot of nothing, which most of the time you can get by and it'll be fine. But in this case, things started going wrong on the project with there were issues, whether it was with the building or whether it was with the stain. It started to chip off. And so this is a pretty big commercial building, and it's not, the customer is not going to be really happy when they're expecting to walk up to a building where they have, where it's this beautiful color, and instead there's just patches of stain that are just falling off and landing on the parking lot. So then the company that had hired my client was refusing to pay, and our client saying, "Hey, it's not our fault. It's not our stain. We'll come out, but you're going to have to pay us." They got a little contentious, and they ended up the company that had hired my client ended up bringing a lawsuit, and what resulted was a year and a half's worth of expert testimony and trying to figure out what the actual issue was, and the parties not agreeing, and this husband and wife having to come to Michigan in between driving all across the country, doing all their other projects where they're trying to keep their business afloat. And we had to have some pretty serious conversations around, hey, your business may not make it, because this was like, there was at certain points, it just felt like there was no end in sight. And if the contract, and I'm not saying that the contract is the end all be all, but if the contract had a little bit more teeth in it, was more clear, really spelled out things like, who's responsible for A, B, and C, they could have avoided a whole lot of stress, a whole lot of heartache, and potentially the lawsuit. So that's why I get really passionate about contracts and making sure that they're properly drafted. All right. So the stats, why contracts matter. So 10% of small businesses face employee litigation every year. Thinking, okay, what does contracts have to do with that? Employment agreements. IP theft, that's a really significant issue. John, I'm sure, has plenty of stories when it comes to IP issues, but in your contracts, you can address things like IP ownership and licensing and things like that. Cyber attacks, that's something that cybersecurity is something we address in contracts. And then just 60% of small businesses face disputes with vendors and suppliers. And just like that example that I just gave, the goal is that with a contract, you'll be able to address certain things that will hopefully either help resolve a dispute or maybe potentially even avoid a dispute rising to the level of, some type of significant, I guess, arguing and ultimately a lawsuit. All right, don't panic, got you covered. So what a contract can do for you. I look at a contract as a roadmap for the relationship. Like I said earlier, a contract is never going to address every single potential issue that comes up. But the goal is, with a properly drafted contract, it's at least going to give you some guidance on how the relationship is going to go from start to finish. I often look at a contract, it's like a prenup plus, right? You're getting into a marriage with whoever it is that's on the other side, whether that be a vendor, whether that be an employee, your customers, things like that. And you're laying out the rules of how this relationship is going to go. Hopefully it's clear. Hopefully, you're adding as much detail into it as possible. And then when maybe there's a question of, okay, well, what are we supposed to be doing here? Or you're thinking there might be a dispute, you can go back to the contract and say, oh, actually, this is what we agreed upon when things were good, which is when it's the best time to negotiate, right? So, that it's really that North Star of, okay, this is how we intended for things to go. It also sets the tone for the relationship. I have found, a lot of times I'll have business owners, they just want to rush through the contract process. They're excited. They're ready to just jump into whatever it is that the deal is. And I tend to be, the one that's like, all right, let's slow down. Just, we don't have to slow down and drag this out for months, but at least let's, make sure that the contract makes sense, et cetera. But also I'm looking at how is the other side acting in the scope of the negotiation. I've had customers where they're negotiating with vendors and it gets really contentious and the other side is very abrasive and they're quick to just refer to other people and they're blowing up my clients' phones with like, what's going on, right? That oftentimes tells you exactly how the rest of the relationship is going to go. And you can look at that and decide, do I actually want to even be in a business relationship with these guys, right? Because that's more likely than not going to carry over into the longer term relationship. A good contract provides clarity on each party's responsibilities. I think a lot of times when we're putting together a contract, I'll have clients say, oh, well, you know what, like this makes sense to me. But then when you actually read it, and I'm reading it as a third party who doesn't necessarily know every single detail of the business relationship, I'm like, this doesn't actually make sense, right? So a good contract is going to be really clear and specific about what each side is supposed to be doing. Again, that goes back to that roadmap piece. If you're hiring somebody to do something for you, your contract's clear, and then they come back and say, hey, I'm actually not supposed to do this, or you're saying, we expected you to do this. We can look at the contract and see, okay, no, that's right there. It's under Section 3, right? Risk identification and management. This is a big one. As with any relationship, you're more likely going to have to compromise in the contract negotiation. And so that's an opportunity for you to think, okay, what are some of the risks for me coming out of a contract? So for example, in the cybersecurity data privacy world, each side is more than likely going to have some type of responsibilities when it comes to protecting personal information or confidential information, whatever that may be. And let's say the other side is not willing to agree to certain security requirements. Well, at that point, you then can assess that and say, okay, that's a risk. I'm going to limit the types of information that I'm providing to the other side. And then you get to put policies and procedures in place on your end to make sure that you're properly protected. And I've already touched on this a bit, but prevent litigation, again, that roadmap, that clarity, even if things start to get contentious and lawyers get brought in to try and help resolve the dispute, a lawyer may be able to look at your contract, or you may be able to look at the contract and say, actually, like this, this is actually what we're supposed to be doing here. And then it just removes the threat of litigation, because it's like, oh, well, there's no basis for a lawsuit. And then I'm going to defer to John on this last point, legal protection in the event of a dispute, right? What does the contract say about your dispute resolution process? Do you have to go to mediation? Who's going to deal with attorney fees, things like that? John, I'm going to kick it over to you with I guess the teeth of the contract.
Yeah. And I think I always like to think of contracts as it's a relationship, right? So it starts with a relationship. And, as someone that's been involved in lots of contract drafting, and it could be for very, what I would say, small amounts, under $1,000, $5,000, $10,000 to very large amounts, right? Into millions of dollars. There's kind of analysis that I think is really helpful. And that is, hey, what happens if the other side doesn't perform or the other side doesn't pay? Excuse me. And so there is a kind of a back and forth, right? And how do you protect yourself, to me, is the ultimate question. Like, what do you do? And a lot of times people think, oh, we can just sue them. Like, that's it. We'll just sue them. But if the contracts, let's say someone owes you $1,000, it costs money to sue someone, and it usually costs more. I would say almost always costs more than $1,000. So then you're in this game of, hey, do I actually try to sue and pursue some litigation, go to court, right? And sure, lawyers, we want to do work. We want to, like, if you want us to sue someone, there's many lawyers. I don't like suing people, but there are many lawyers who will say, yes, let's go, let's do it. But I'm more practical. I say, well, wait a sec. Why would I spend $10,000 to recover $1,000? It doesn't make sense financially, right? And probably if you're smart and listening to this, you're thinking the same thing. Gosh, I don't want to do that. And sometimes it's emotional. Sometimes you really just feel like you were wronged and you want to make a point. But there are dollar amounts where you should protect yourself more than just thinking we'll just sue. And sometimes it's a lot of money. Like, so for example, this was maybe a year and a half ago, or maybe 2 years ago now. There was a dispute, and it was, I think, about $75,000. And I told the client, to litigate this, it's going to cost you at a minimum $30,000, $30,000 to $40,000, I would say, at a minimum. So I advised settling. I said, if you're just thinking about numbers, even though they owe you a fair amount of money, I would advise try to settle, right, for less than 75. I think it was, and I don't remember the numbers exactly, but let's just say I said offer, 60, or offer some lower amount. And they initially disagreed with me, and they offered $5,000. Or the other side, I'm actually mixing up the story, but the other side essentially, he only wanted to pay $5,000, but they claimed that he owed 75. And so he said, well, I'll offer him 5 and see if we could settle. And of course, the other side said no. But once we did eventually settle for $49,500, he said, why didn't I listen to you at the very beginning? Because he still had to pay legal fees. So in a sense, like, there is a dollar amount where it costs money to litigate, right? And it costs money to solve the dispute. So when I always talk about contracts, I always say, what guarantees performance? Like, so for example, if you're accepting money and you're performing a service or you're supplying a good, right? Get the money up front. That's what protects you. And similarly, right, if you're on the other side, have some protection, like don't perform until you get some money or till you hit some milestones. And you can build those all into the contract. And this is just good business sense. And I would suspect many of you already do these things. It's just memorializing it in a contract if you haven't already. But it's just a great way to think about, how do I protect myself if there is a dispute, one side doesn't perform. And there's many examples I could talk through if anyone has more interest, but that's just understanding what's going to happen if the other side doesn't do what they say. That's really important for when you're looking at contracts.
Yeah, and the example I also always go back to is attorney fees. I think there's this misconception that if there's a lawsuit, automatically the winning party is going to get attorney fees, right? And so going back to that original example with the staining company, they're like, well, we didn't do anything wrong and they should pay our attorney fees. And I'm like, well, it doesn't quite work like that. And you also crossed out the section on attorney fees in the contract for some reason. And but regardless of that, it's not a foregone conclusion. So to John's point, you're running the risk with a poorly drafted contract that you're going to have to pay X amount of dollars, even if you don't feel that you're on the hook for it and you should pay for it. And also you are going to be responsible for your own legal fees. All right, so diving a little bit further into, I guess, specific provisions to consider, and there's no one size fits all contract, of course, but these are just some things to think about that I think sometimes are often overlooked. But we're going to start with IP and our IP guru, Mr. Mashney. So
Yeah, I think intellectual property, I'll just tell you some of the big things I notice, right? And this happens all the time. You hire someone to create something for you, or many times you're creating something for someone else. But let's just say you hire someone to create a logo for you or to create something that is intellectual property, right? Could be video, could be marketing materials. Like I said, it could be your own logo. And you think, hey, I paid them money. I own whatever they create. Well, the crazy reality of the legal landscape is that just paying someone money doesn't mean that you own it. So I've had tough conversations with people. They say like, well, I own my logo. And I say, well, show me the agreement, show me the contract. And they say, well, there isn't one. I just paid them. Well, in many cases, if there's no written agreement and nothing else governing that, you don't actually own what you paid for. You might have a license to use it and the rights to use it, but you don't own it. And in order to file like copyright application or to enforce many times like your trademark rights, you need to actually own what you think you own. So that's all by agreement. There's certain language that has to be in those agreements if you want to own certain things. So that's something that's important to just think about. It's like, do you actually own what you pay for, what you think you own?
yeah, and I think even going a step further, and this goes into the confidentiality piece, what rights are you giving to somebody else to your own IP, and we'll call it your secret sauce, right? Like I talked to a client earlier this week, and they provide repair services and within the hospitality industry, and they're partnering with a much larger organization that has a relationship with McDonald's, right? And they're potentially going to be able to get into a broad relationship where they can service all of McDonald's locations in the United States. Awesome. That's really exciting, potentially life-changing for the business. The problem is they're rolling out a pilot and they've been working on this pilot for the past 2 months. No agreement. And my client is talking about, okay, we've got this like secret sauce process that we use when it comes to providing repair services, et cetera. And they've just been handing this over to this larger company that has the resources and the time and the money to develop a competitive product. And so we were talking through this the other day, and I'm like, okay, how do we correct this now? But that's really highlights, I think, the importance of having confidentiality agreements in place, having things in related to IP and your agreement with the other party of like, okay, I'm bringing this to the table. and I'll give you the ability to use it in the context of this relationship. But at the end of the day, that's mine. You don't get any ownership. You know, we can talk about things like you're not going to create a competitive product. You're not going to solicit my customers if you create a competitive product, things like that. And so, you know, I think oftentimes I see business owners get really excited about making these handshake deals. And it's like, no, 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 I trust the guy. I trust the guy. And I'm like, now, like, but you don't actually know him, right? Like, people don't go into a marriage thinking like, we're going to do this and get divorced. It's going to be great. And so, you know, it's really about thinking through like, okay, what could go wrong and how do we make sure that we're protected? And then that your business is protected in the long term. And then, you know, as far as data privacy, I'm sure you all have heard of GDPR or the California the Privacy Protection Act. And, you know, there's a whole lot of obligations that companies have now with respect to personal information. And so that's one of the things that you also want to be really paying attention to and making sure that you're doing what you're supposed to be doing and the other side is doing what they're supposed to be doing, because in the event of some breach, you know, we've all heard about these situations where there's been big data breaches. You could be on the hook for paying for fines because your vendor or somebody that you're in a business relationship with had a breach. So paying attention to that is also really important.
Carolina, we do have a question in the chat. Brian is asking, are non-competes going away in Michigan? Have employers been moving to non-soliciting contracts?
Brian, I'm going to answer that with a question. Are you talking about from an employee? I'm assuming you're talking about with as far as employees, or do you mean non-competes with like customers? I guess just a little bit further context. And you can unmute. You can unmute yourself.
Yeah, I allowed you to talk.
Oh, and more from like a subcontractor, somebody who's helping write business for the agency.
So as far as them soliciting your employees, or
no, shared business. I
Oh,
went
okay.
to I went to probably about 2 months ago. I went to another legal presentation, and they were saying that Michigan is doing away with non-compete agreements or something, and I don't know. So that's why I
Yeah,
wanted a little bit more information on that.
sure. They may be referring to John, was the FTC that that basically said no to non-competes. But there was a challenge, I believe it was in Texas, where a federal judge ruled that basically put that on hold. So I guess the answer that is to be determined. Right now it's something that was supposed to kick in, but now it's working its way through the courts. So I think we'll probably have more clarity on that in the next couple of years.
Yeah, I can add a little, Carolina, too.
Sure.
Just so, Brian, from my experience, yeah, like the FTC, Federal Trade Commission, essentially proposed a rule that said non-competes aren't enforceable unless in certain circumstances, and generally it's for very high-paid executives and for in the sale of a business. So if you sell a business, then the person who then you would be subject potentially to an enforceable non-compete, right?
Mm-hmm.
And those laws actually exist. Very similar laws also exist in some states, like in California, for example. So there is a trend that non-competes are disfavored. And I have seen Michigan employers basically say, we're going to get rid of our non-compete for our Michigan employees, but we are going to strengthen or at least make sure that we do have non-solicitation provisions. But when you do that, you just have to make sure that your non-solicitation doesn't function as a non-compete. So but they're just trying to anticipate where the FTC and where that rule's going, because a lot of people are upset about it and they're trying to weigh well, hey, the FTC doesn't have jurisdiction to tell states what to do, essentially. And so
Yeah,
there's
that's what I was kind of thinking. I was like, is the Federal Trade Commission the people that can decide that?
that's what's being litigated right now. And so what I would say is, just if you do have a non-compete, you're going to have to be careful about it. And I would say even without this FTC proposed rule, you still need to be careful, right? You still do. And you still need to look at your non-solicitation clause too, because there's lots of nuances to it, how it's read, would it be enforceable, right? Because it has to be reasonable in duration and scope, right? And geographic scope too. So there are a lot of things to look at with non-solicitation and non-compete provisions, but they are important. And I think they're in, a lot of companies use them and a lot of people don't understand. I literally 9 o'clock this morning was talking about a non-solicitation dispute, and there's a lot of back and forth. And, I was arguing with opposing counsel a week ago saying, what is solicitation? We're fighting, what is it? Right. Like, and it's not always clear based on what an agreement says. So I do think the posture generally is non-competes are disfavored. Non-solicitation will be enforceable, though, even if this FTC rule does go through.
Okay. Thank you.
Yeah, you're welcome.
Yeah, and I would also add, and this is probably more nuanced than necessary at this moment, but because we are so close to Canada, Canada has been also moving in the general direction of effectively illegalizing non-solicits and non-competes. There's definitely, it's nuanced and it's dependent on where it applies, but if you're doing any type of business in Canada, that's something to at least generally be aware of. That was a hot topic discussion earlier this year. So I think that's similar to the FTC rule. I think that's making its way through the courts. So just something to be generally aware of.
Awesome. Appreciate it.
Yeah, no problem. And Carol, totally agree. Trademarking your unique name is definitely worth the effort. And I think John would certainly agree as well.
Right. Yeah.
All right. So other key provisions to consider, and John touched on this briefly as far as performance expectations. I always go back to the example of when I've had clients negotiate with some type of SaaS software vendor that's giving them, creating some type of system for them that is effectively going to be going to be the underbelly and foundation of their business, right? Usually that's very expensive. You're probably looking at, over the course of the agreement, you're looking into like the millions, right? But nobody wants to pay that up front. The vendor wants you to pay up front. And so how do you work through that? And how do you, if you're paying up front, how do you address an issue if something comes up where you don't feel that the vendor's actually delivering on what they promised, right? You've already paid the money. Well, now what? And so this is where I like coming in and thinking through, okay, what are some other payment structures we can come up with? And are we going to have milestone payments where we're actually happy? Like once we confirm we're happy with, let's say, phase 1, well, then we're going to pay you. And then it becomes a little bit more intentional, and both sides have some skin in the game over the course of the project, but it's also not heavily favoring one side or the other. And like I keep saying, just in general with performance expectations, make sure it's clear what you're doing. The best thing that I had a partner ever say to me is, can a third party who knows nothing about this agreement pick up this piece of paper, read through it, and at least have a general understanding of what each side is supposed to do? It needs to be clear, right? I often get initial drafts of agreements that are super vague, and I kind of know what's going on, but then I'm reading it and I'm like, I as the third party could genuinely not actually tell you what we're supposed to be doing here, who's paying what, like who's responsible for making sure this gets done, etc. John, do you have anything to add on that piece?
Yeah, I always think in milestones, right? And depending on what's being done, right? If you're in, to me, contracts are all about risk management. That's like 100% what it is. Hey, if I perform this, what's my expectation? But then also, what's my overall risk in the agreement? So, for example, I'll tell you this: I dealt with a company who hired a vendor, and it was $100 a month contract. Okay, $100 a month, so $1,200 a year. So you might think there's only $1,200 at stake, right, on a yearly basis. However, somebody breached the contract. The other party breached the contract, and it resulted in a $2 million loss. So is it a $1,200 contract per year, or is it a are you exposed to $2 million of risk? And that's the point of having provisions in your contract. You might say, hey, limitation of liability. I'm only liable for X dollars, no matter your damages, right? And in that's a particular example where you might think, oh, my contract, I'm only charging $100 a month or $50 a month or $1,000 a month, but there might be exposure to you that's much higher. So thinking about in the contract how you can mitigate that risk, that's why it's important to think about and understand. It's not just the dollars, it's the risk that's associated. And then how do you allocate that risk? So that's where, to me, it's always important to understand. In certain types of contracts, we would always say, limitation of liability. We would always have indemnity. We'd always bring something like that up. And it's easy to think it's not important because you're used to just like, hey, this is how it's always been, and I have never had this happen. Until something like that happens, then you're like, oh my gosh, what am I going to do? And sometimes you have insurance that helps you, but sometimes you don't. Sometimes insurance will say, no, this isn't covered loss and you got to pay it yourself. So I think that, to me, it just goes back to what's my overall risk in this relationship, on the upside and the downside.
Yeah, 100%. And then, going even further with like termination, right? Let's say something's going wrong. What can you do about it? How can you get out? And, I think, and also on the flip side, like, let's say you're the service provider and let's say you're manufacturing something for a client and you're investing all this time, all this money, etc. And your customer has the right to terminate just because. Well, now now what, right? You've put in all this time, you put in all this effort, and now they get to walk away. So, as far as termination, you always want to make sure that those rights make sense. I think a lot of times people are like, no, like we're not putting in all this time and effort in order to just walk away. And then there's new leadership that comes into play, or, their financial situation changes, or whatever the case may be. It needs to make sense, right? Based on your role. And because if you're the customer, maybe you do want to be able to walk away whenever you feel like it. And then maybe the other party is saying, well, we don't want you to be able to do that because we're the ones investing. So instead, we're going to ask you to pay a certain fee to walk away. And just like thinking through those types of things, like what are you comfortable with in the event we need to end the relationship? Dispute resolution. John has talked a little bit about this already, but if there's a disagreement, how do we resolve it? I think when you're entering into the relationship, it's a really good time to talk about how are we going to handle problems. Maybe that means mediation. Maybe that means some type of escalation clause where it's like, okay, we're having issues and we're going to make sure that we take 5 days to level it up to a senior executive. And if that doesn't work out, then we're going to level it up to somebody else, right? That to try and work things out with between the parties themselves. Okay, but now let's say there's an issue where it can't be resolved at that level. Do you want to think through having mediation? Does it make sense to have an arbitration provision here? If we're going to go through the court system, where are we going to, if you're in Michigan and they're in, let's say, Nevada, well, where do we want that lawsuit to be? What makes sense? Because I think the last thing any of us want to do is have to travel to Nevada where they have home court advantage and you're spending all the money to find an attorney out there. You're spending money on traveling. Like my client that did the masonry staining, they were out of Pennsylvania. And so they would have to come to Michigan for depositions, for court hearings, this was before, well before COVID. So like they were driving out here. I'll never forget their truck pulling up every couple of months, having to come back for whatever reason. And I already talked about this a bit, but who's responsible for attorney fees? It is not a foregone conclusion that if you win a lawsuit, you're going to get attorney fees. So that's something to consider. And then as far as liability limitations, John talked about this as well. If you're the service provider and you're only being paid X amount of fees, are you capping your liability at an amount that actually makes sense based on the spend? And conversely, if you're the customer, let's say you're handing over a ton of confidential information, a ton of personal information, and the other side wants to cap their liability at, say, $1,000. Well, that's probably not going to make sense for you, right? Because in the event of a breach, or in the event they take your IP and they run with it and create a competitive product or whatever it may be, and they're just a bad actor that, their mission in life is to bring you down, you want to make sure that you can go pursue damages against them that actually make sense. And so those are things to think through. And with liability limitations, there's always going to be some level of compromise. It's very rare that either side gets exactly what they want, but at least you're thinking through what the potential risk is. And that also goes back to that risk management piece that I talked about earlier. John, do you have anything to add on that one?
I think the biggest thing goes back to calculating what's your ultimate risk in any contract, right? Sometimes you do want to think about what's the cost of litigation. So if it's a $10,000 contract, you don't want to litigate a $10,000 contract. You want to make sure, and so how would you do that? Well, maybe you have a, hey, winner gets attorney's fees provision, or maybe you just say, hey, there's certain things to protect you so that if the other side doesn't perform, either you still get the money or you didn't take that big of a loss and you can just walk away and say, I'm done. We're just, we have some termination rights, but we protect our downside. So to me, it's like understanding, hey, what's the business relationship and how much money is at risk? And then thinking about ways to mitigate that risk. And that's the kind of stuff that we help with, right? We talk to people about this, which is you can even think through it yourself. You don't necessarily always have to, we can help, but like you control that more than anyone. You can think through, okay, how much money would I lose? Is this covered by insurance? Do I have the right coverages that even cover this type of risk, right? Or this type of relationship. And so you can think about those things yourselves because you know your business better than anybody.
All right, common pitfalls. I think the number one pitfall that I see is just not having a contract. I have a family member who owns a business that deals with large dollar amounts. I don't think the man has ever signed a contract in the entire time that he's at his business. And every time we're talking, and it usually comes up every couple of years where somebody hasn't paid him. And then he's like, well, what do I do now? And I'm like, well, did you sign a contract with them? And the answer is always, well, no, we just it was a handshake deal. I'm like, okay, well, options are limited. So, maybe we can start having that conversation about having a contract. Even if it's something simple, right? Like I understand there's time and effort that goes into putting together a contract, and you could spend a lot of time on contracts, and there's more efficient, effective ways of putting together contracts, especially if you're dealing with smaller deals, etc. But have something in place, please. That being said, using contracts that don't apply to your business or the transaction is also not helpful. I think, there's things like LegalZoom out there, or people will pull drafts off of the internet, or somebody just has a template and they're like, oh, we're just going to use this, and they kick it over, and it's like, okay, but this doesn't actually address any of the risks. This doesn't actually talk about what we're supposed to be doing here. I had a client send over their template that they put together. I think it was in 2004. So it's 20 years old. And one of the things that they're doing is they're hiring consultants to help them develop products. And, we can get into all the things related to IP and confidentiality, et cetera, that we talked about before. But as I was reading this, he's like, let me know if you have any updates. And it's a newer client. I'm like, okay. And I'm reading through it, and I'm like, why does this say that you're providing the consultant services? And he's like, what? And so they've been using this contract that effectively says the opposite of what they've been trying to accomplish for the last 20 years. And I'm like, where did you get this from? And it was just, nobody had actually read it. They're like, oh, well, this is a consulting agreement, so it must be right. So, so we're in the process of fixing that. Vague or broad language. Hopefully by this point, you understand my strong stance on making sure that things are clear. you know, to the extent that you can walk into the contract process, and I understand that you can't always do this, but if you walk into it and you know there are certain things that you're expecting the scope of work to include, or you're there, you know, there are certain things that you're expecting your contractor to provide for you, or dates and deadlines or fees, things like that. Be as specific as possible. The more detail you can put in the agreement up front, the better off you're going to be in the long run. And then the final one, which always gives me a lot of heartburn, is just leaving it to the lawyers or not bringing legal in early enough. You know, we're always happy to review an agreement, but obviously that takes time. But also, we're not in those discussions that you're having with the other party as far as what you're agreeing to, what is exactly you're doing. Like, I really pride myself on getting to know my clients and understanding their business and understanding their strategies and their growth plan, etc. But I still don't necessarily, like, I'm not in it day to day. And so if I'm being sent a contract and it's like, oh yeah, just send it over to the lawyers, let them take a look at it, and you know, they'll let us know. There is no way for me to really truly understand, like, does this actually say what you want it to say, right? So make sure you're also reading it. I know that it can sometimes be a bit of a drag because, again, it's a lot of words on paper. But you know, you want to make sure that it makes sense from your perspective, and then kick it over to the lawyers, and then we can take a look at it and be like, hey, you know what, like, if we're actually looking at the language, like, are you sure you want to be doing this with IP, or what about the risk, right? And we'll look at it from our perspective, but that allows, you know, you to at least have comfort knowing, like, okay, this is saying what I think that it says, right? So, and again, bringing it in early enough, like if you need a sign tomorrow, like, you're not going to get as much of a well-rounded review of the agreement. And if, you know, worst case scenario, you haven't reviewed it and you get it over to legal and they're looking at it and they're like, hey, did you know it says this? And the agreement doesn't actually say what you thought it was going to say. You know, at that point, we're starting off on the back foot of trying to, like, okay, how do we make this make sense?
Can I jump in, Carolina, too? I
Of
think
course.
I know we're getting close to the end of the hour here, but and Kelly, can we be interactive? Can I ask people to raise their hand, or will that not work? Okay, so
Yeah.
this is a test to see if anyone wants to participate. You don't have to if you don't want to, but I'm just going to ask a few questions because I do think there are some other pitfalls that come up in contracts. And here's a big one that I'm literally dealing with right now. Like, this is a real one. Do you think, let's say you got your contract signed, good job, your lawyer, you have a great lawyer, maybe it's Mavacy, maybe it's not, it doesn't matter, right? Your lawyer signed off, you got the contract, everything's great, you feel good, you got paid, you're ready to go, like, things are happening. Can an conversation after the contract has been signed, can that change the contract? What do people think? If you think yes, do we have like a thumbs up?
Yeah, down, if each of you hover down at the bottom, there's an icon where you can raise your hand.
Okay, so let's yeah, I'm just curious what people think. Can a conversation, okay, so somebody says we have a couple of yeses, one, okay, a couple of yeah. What about an email? You send an email, can that email change the contract? What do people think? Raise your hand if you think yes, the email can change the contract. Okay, signed written contract. Okay, a couple of people raise their hand. What about a text message? Like, if you send a text message, could you change the contract that you signed? Raise your hand if you think yes. Okay. The answer is yes to all three.
That is
go ahead.
shocking to me.
Yes. So I think this is really relevant because it's fresh in my mind, where I feel like I told the client, I said, don't do anything, don't say anything. And the person came back to me and was like, I didn't say anything. I didn't say anything. And then she said later, but I did send this text. And I said, well, send me the text message. So, you know, is not really a good way to send text messages. She sends me a screenshot, and it literally, she changed it. She agreed to something that I told her not to agree to, which she said she did not agree to, but it was in a text message. And I just was like, oh no, what are we doing? Right. So that's something to be aware of. Another common, and it's easy because when you have a contract, you go through it, you vet it, you might read it very carefully, you pay a lawyer to review it, or maybe you have someone on staff, very sharp person. A lot of like people in executive roles are very comfortable reading contracts. And then somebody gets a text message or an email and they reply yes or no, or something along those lines, because it's way more informal, right? You don't ask lawyers to vet your text messages, every text message you send, right? Or every email very often. But the reality is that is an agreement that can be enforced either as a new agreement, like if, hey, well, maybe we don't have a contract, but we have all these text messages back and forth, right? Or an amendment to an existing agreement. So either some people were just zoned out and weren't, answering, or they, hopefully we helped kind of shed some light on I think a very important part of a contract is you can have a conversation, and if there's an agreement, the other side can say, no, we amended the contract based on what we talked about after we signed it. So that's something to just keep in mind when we're dealing with contracts.
When I think to that point too, when we're talking about, let's say, scope of work, for example, and you're saying, we know this right now, but there's going to be things that we're going to discover as we go through, and we're going to fine tune this, right? And that's where it that really comes into play as well, where it's like your team is talking through things, and they're talking about approach, and they're talking about scope and this, that, and the other thing, and they're agreeing to things after the fact, and then that's when you run into that issue. So it's really, which I think leads into my other good practices, recommendations, is this last point: train staff on handling contracts, right? Like, make sure they understand what they, that you, for example, like what John was saying, that you can amend the contract after the fact. And also, as going to back to this top bullet point, contract management, have some type of system in place where you can manage things like, what's the term of the agreement? What are my confidentiality obligations? Like, how long do I have to keep this stuff that they're giving me confidential? What are my termination rights? Right. And it can be a little bit of a drag up front when you're trying to put that system in place. That's a really effective way to give your staff information on things that they should know about the contracts that you're entering into. We've talked about risk management and, things that come up when you're negotiating contracts, where you're like, oh, this is a potential pitfall. Well, how are you going to manage that? What policies are you going to put in place? What procedures? Are you only going to give certain staff access to certain information, or, how are we going to disclose information, or whatever it may be, right? And then review contracts periodically and update as necessary. We'll go back to my 2004 template. Probably should have updated that a long time ago, but it's fine. We're doing it now. But, take a look at either your executed contracts, right? See if there's things that you agreed to with parties that, don't necessarily make sense today. Maybe they don't reflect the agreement today. Maybe you have made a lot of changes over the course of the relationship that you need to memorialize. And then, as far as templates, like looking at employment agreements, looking at, your service contracts, things like that, and see, like, does this still make sense for my business today? Because what worked even 5 years ago, it's a very different world than it was 5 years ago, may not work today. John, any other?
Yeah, guys, I think having worked with different entrepreneurs, contracts of all sizes, companies of all sizes, let me give you a few kind of tips. This is like worth the price of attendance right here, okay? Because lots of people say, John, can you review this contract? I have no money. Or, John, we have a budget. And we work with people all the time, all across the spectrum. So one thing, I think, how to save money on contracts. I think that's a big one. Number one, how to save money on contracts. Understand, is this a one-off contract, or am I going to use this type of agreement over and over and over and over? Because if it's a one-off, then you understand, like, does the cost to have it reviewed or have it really looked at by an attorney, you just weigh it against, hey, what, like all the stuff we talked about already, right? You have to make that determination. But very often it helps you to have templates that you can just work with, where you just pay for it one time to get a really good template, and then you just use that template over and over and over. And then if there's deviations to it, then that's where you bring your attorney in and you say, hey, does this make sense? That's how you can save a bunch of money on contracts. And then you can even ask that attorney to say like, hey, where are the points where I can accept? I've done this numerous times, just did it for a client about a month ago. They said, hey, what deviations from what amendments or what changes should we just accept because they're fine? And which ones should we ask you about? Which ones are risk to us, right? And we gave them a list. There's 12 things. These are acceptable changes, but we want to start with this version because it's more protective of them. And these are changes, really don't change these sections unless we have a conversation, right? So I think those are some easy ways to think, oh, how do we make contracts work for us, but we don't have to spend all this money getting them reviewed over and over and over, right? So that's number one. Number two is have some type, depending on the size of your organization, have some type like Carolina said, some type of contract management, but also contract training. Like, hey, who is actually allowed to sign contracts? Who is allowed to change contracts? What's the process to amend contracts? Those kinds of things. And it might seem like overly simplistic, but it is a big deal in terms of when you start dealing with bigger contracts and things like that. So, and then the last piece I would say is look for changes in payment information and put that in a contract, because put the amendment, what's required to amend payment information, because, and maybe it's not totally in the scope of this presentation, but I'm just trying to help you as much as I can with all these wire transfer fraud things that happen where people spoof your email and then they change payment information and somebody doesn't know. And to protect your company, I always advise people, any change, if there's going to be constant payments, any change in payment information requires a signed writing that must be approved by a certain person. So that gives you some protection if you do have to go engage in litigation. So those are three things I think really good practices for people to keep in mind.
And I know we're running out of time, but so basically, in conclusion, contracts are not the end all be all, but they do serve as a roadmap. Take the time, read your contracts, make sure they make sense, make sure you understand the risks involved in it. And if you need us, we're here, but there's also plenty of other attorneys that can help you out. And just if you're questioning it, make sure you talk to a legal professional to understand, what it is that you're actually agreeing to, because it could really be the difference between your business like thriving and doing great and unfortunately potentially going out of business. And I know we've got 1 minute, but yes, any questions or last thoughts?
So each of you can unmute yourselves and pose a question, or you can write it in the chat, however you prefer.
And I've also got our contact info on the screen if you want to reach
Yeah.
out to us after. So,
All right. Well,
Cool.
thank you. And we did record this and we'll send it out via email to everybody who attended, and it'll also be posted on our website for you to share or go back and rewatch. So thank you. Thank you so much, Mavacy team. We value and appreciate you all so much. And thank you, members, for joining in. And oh, wait, there might be one question. Oh, just a thank you. Okay. Thank you. Thank you,
Thanks, Rob.
everybody. I hope you all have a great rest of your day.
Thanks all.
Okay. Bye.